Officially, let's go ahead now that I have most parties present on 23 and, excuse me, on 26 and 27, Alexis Rodriguez and Frank Artilla. So let's go ahead and have everyone state your appearances for the record. Mr. Bailey?
I think we're missing Patrick.
Yeah.
Your Honor, I'm texting Ms.
Okay.
Diamond for
Okay.
to see if we can get this done.
Maybe someone else can cover it. I'd have the defense team announce your appearances if you wish.
Yes, Your Honor. Good morning. Frank Montero, Legniomi, Leccionito, on behalf of Mr. Artiles, and Mr. Artiles is present, Your Honor.
Good morning to everyone. And we have some folks on behalf of the media as well. If y'all want to state your appearances, good morning.
Good morning. I'm not sure where. Dana McElroy on behalf of Miami Herald, New York Times, Quebec Company Inc., Key Biscayne Independent, Florida First Amendment Foundation, Florida Center for Governmental Accountability. Those are all entities that have sought to intervene, Your Honor.
All right, very good.
Health Rooms on behalf of the Relational Center, who has also.
Anyone else? Okay. So we just need Mr. Van Diesen on behalf of the state. trouble at all, not yet.
I was gonna say, I usually have to work my way to that.
Always not. All right, and we've had everyone already state their appearances for the record. And so we're here for a couple of different reasons. The defense motion that was originally filed, and we have a motion to intervene filed by our several media outlets. Mr. Vanderdeesen, I was thinking I'd go ahead and turn it over to the defense for right now, but did you have any preliminary matters you wish to discuss?
No, I did not. I don't know if the attorneys for the media. No, Judge, this is really a defense motion, so
Yeah.
I agree with Your Honor. We'll defer to that.
Okay, perfect. Let me just see. Danny, can you? Della, is that- I'm sorry? You're not connected to the audio? It's the live stream that I'm having a hard time. There's a lot of feedback and it's a delay. It just stopped though. No. Give me one moment. Okay, let's give it a try now. About the end of the line for my technical capabilities. So, all right, so you may proceed on behalf of Mr. Ortega.
Thank you, Your Honor. Please support, Judge, we're here, as the court stated, on the motion for protective order that I filed. And I want to be very clear, because there have been reports in the media that we were trying to prevent evidence from being disclosed to the public. I think the court, after reviewing my motion, will agree that that is not the case. We are not trying to prevent the evidence in the case, or whether the state deems to be evidence in the case, from being disclosed. However, we are trying to prevent the non-relevant material in the possession of the state from being disclosed for a number of reasons. And the press is taking a position, they're not all taking the same position. For example, the Miami Herald and the newspapers or the media that their attorneys represent take the position that while this stuff or this non-related material may come within 119, they've set out in their motion, and I'm not speaking for them, and I'm just simply repeating what is in their motion. There's a series of categories of items that they're not interested in. Unfortunately, and this is one of the reasons why we have not been able to resolve this matter, the Orlando Sentinel takes the position, the extreme position, that everything comes within 119 and everything in the possession of the state needs to be disclosed, which in the case law is totally contrary to that. Now, having said that, we met with Mr. Vanderdeesen and with Ms. Solomon to try to come up with some type of a preliminary agreement on what is to be turned over and what is not to be turned over, and the things that are going to be turned over, in what form are they going to be turned over. And as we know, and I want to be very clear with this court, we are governed by Rule 3.220. That is the procedural mechanism by which we must proceed on. 119 is not the holy grail, because 119 specifically says that it is not intended. I'm going to read to the court, okay?
That noise out there on the phone. Yeah, it's way too loud. Okay, go ahead. I apologize.
The courts that have interpreted 119 have gone over and over and over again and stated, all the way from the Supreme Court down to the appellate courts, have stated that the purpose of the Florida Public Records Act is not to catch private individuals when information is unrelated to the business of municipality, county, or state. And that's Times Publishing versus Clearwater. They went on to say, private information does not become available to the public merely because it is in possession of a public agency. At 347, I'm sorry, at 847. That case held that private emails of public employees stored on public computers were not subject to disclosure under the Florida Public Records Act. The courts have also recognized. Sorry, they're talking in the background, and I don't know if the court is hearing me.
Yeah, I'm hearing everything you're saying, but I'm
This is very distracting.
trying to figure out if it's still this live stream situation. If it is, I'm gonna mute everything. Give me one second. But if somebody else, that's all. It's not. I'm muting myself. This is very distracting and I need to be able to conduct. Where is that? Sorry, guys. I'll be right back.
No problem.
It was welcome.
I didn't realize it until Saturday morning that I went to anchor over at Steel Bank. So I tied all the front of my boat.
It was a piece of tied a chain to the anchor.
It's a swivel, it's a swivel, and I can change the front part swivel. So the anchor
It came out of the chain.
Did you do some fishing like this?
We fished a little bit on the way down. We got out super late. I believe dawn till about 11:30. Just the water's just too warm. And just for about an hour, didn't catch anything, and then we drove down. But the ride back yesterday was incredible. I was expecting this really bad weather. And the ocean was like, I came on the inside, on the base side. The ocean was flat as a pancake.
I'm thinking maybe the March, I'm not sure. This been out for a long time. Every time I come to this place, this computer, it's supposed to be fixed. Really? Mm-hmm. It was a priority. Mm-hmm. Now, okay. Yeah, I just had text my supervisor.
Yeah,
So.
but it's, I mean, we
So
can
it's just a matter of
all,
muting it.
so if I'm myself, yes, yeah.
Right, George, good morning.
Good morning, how are you?
Judge DeLo is our technical advisor.
So the question is, who else have, so the only other source, is anybody else running Zoom in?
No.
You should be
You're gonna
busy.
mute
I
yourself.
want you working.
I'm busy.
I have priority.
Thank you all for your patience. I turned my speaker down.
You're not.
Do you want us to try it?
Here's some.
Yeah, you can hear it. Thank God you can hear it, because then
Right,
I was
what are
thinking
we-
maybe we have a separate issue on our hands.
That's the question. Are we hearing next door?
That's all. Here's all.
That would only happen if somebody's on YouTube. The YouTube is the delay. I have no explanation for it. You're not even logged into YouTube.
Well, it went in, that whole private thing. I'm gonna stop the live stream real quick and then go back.
Turn it up.
You're not,
turn it
so you're not
up.
doing any of the.
The other thing that's open. And see, now it's,
Oh, you are on YouTube. There we go. Done it. It was already YouTube, and that's what was happening, so I just muted the YouTube.
Thank you, Judge.
okay, all right, back on the record. Now, let's, your last statement was that it's not a matter of public record just because it's in the possession of a public entity.
Correct, correct. And the cases have so held. Hill versus Prudential Insurance Company of America, it's the first DCA case, 1997, basically held that recognizing generally that private parties' privileged documents do not become public record simply because they are in the government's possession. In other words, a private document does not lose its character of privacy or of confidentiality simply because it has come into the government's possession or the state's possession by way of either a subpoena or a search warrant or another mechanism. It simply doesn't lose its character. And then finally, Judge, the provisions of 11907(8). The provisions of this section are not intended to expand or limit the provisions of Rule 3.220, Florida Rules of Criminal Procedure regarding the right and extent of discovery by the state or by a defendant in criminal prosecution or in a collateral post-conviction proceeding. That's what the cases hold. So the Honor has the power, for lack of a better term, to limit the scope of what is turned over to third parties who are requesting it under 119. And again, we have to distinguish between what is evidence in a case in the possession of the state and what is non-relevant material in the possession of the state. We do not have a problem with the state determining what evidence they have or they feel is in this case. For example, police reports, witness statements, things of that nature are clearly evidence in the case. And again, we have no problem with that disclosure. What we do have a problem with is the certain non-relevant material that has either a confidentiality aspect to it or a personal identification aspect to it. The problem with 119, judges, is that it hasn't evolved with the technology and with the times. The legislature has made no effort to upgrade that to today's situation. Let me explain. Back before we had the internet, back before there was any kind of electronic information data online, there was only three forms of personal identification. There was your driver's license, there was your date of birth, and there was your social security number. That's basically what everyone used for personal identification information. Today, that category of personal identification information has expanded to the point where emails are used as personal identification information. Cell phone numbers are used for personal identification information. So technology has created this, in essence, this new or additional categories of items that are personal identification information or confidential information. And 119 is not evolved to include these items. Now, as I said earlier, 119 is not the holy grail to the discovery information, as I have previously advised the court, citing some of this case law. But even the state will acknowledge that there are certain items that they will not disclose because one, it is either confidential, or two, it's personal identification information, but are not set out as listed exemptions under 119. If I may provide the court, I'll ask the state for permission to do this. In our meeting, if I may,
I'm sorry, did you have an objection, Dan?
I wonder if we might have a copy of what is provided to the
I'll
board.
give you my copy.
Thank you.
Thank you.
Thank you.
This is a list of, and Judge, by the way, the fact that I was gracious to give a copy, I'm not waiving my right to have the court do an in-camera inspection of the 3.220, some samples of documents that I have here. I just want the court to know that. So we met with the state, Ms. Solomon, Mr. Badradis, myself, Mr. Trujillo, and Mr. Quignon, to try to come up with a game plan, as the court had instructed us to do, to make things a little easier for everyone. And we did that. We met for about an hour and a half. And we looked at some of the categories of items. If you look on that list, for example, medical records are on the state's list. Medical records are not on 119. They're not a listed exemption under 119. However, they are confidential under state statutes. And you also have to keep in mind that there is a constitutional right of privacy that Mr. Artiles has, and everyone else in this case has. Anyone that could be affected under Article 1, I believe it's Section 23 of the Florida Constitution, provides us with additional protections so that our privacies are not invaded by the public's demand for knowledge. I want to bring a case to the court's attention, a recently decided case by the 3rd DCA, Hotel Association of New York versus Airbnb, Inc. at 304 Southern 3rd, 1263, 3rd DCA, 2020. This is a civil case. In that case, the court had sealed certain business records and said that they were confidential. It was appealed. That order was appealed to the 3rd DCA. And the 3rd DCA, the court sealed it under Rule 2.420, administrative, the rules of judicial administration. The court held that while the confidential business documents are not included in the list of confidential information under Florida Rule of Judicial Administration 2.420C, any court record may be determined to be confidential if doing so is necessary to avoid substantial injury to a party by disclosure of matters protected by common law or privacy right, not generally inherent in the specific type of proceeding sought to be closed, or to comply with well-established public policy set forth in the Florida or United States Constitution, statutes, or Florida rules or case law. So in other words, and by the way, we need to distinguish here, because what's happened is the appellate courts have interwoven arguments under the Florida rules of judicial administration 2.420, and then the rules of discovery, both civil and criminal, the 3.220 rule and the civil equivalent. And the distinction is important because the rules of judicial, and we mentioned it in our motion only because the state filed a document and it became a court record. And that document is the The original discovery list states demand for defense discovery, which sets out the witness names, addresses. This was filed as a public record in these proceedings. So that thereby triggering the 2.40 analysis under the rules of judicial administration. So I don't know if the court has seen this. I have an extra copy.
I
for you.
have at some point in time, but you can pass it.
Yes. So because that document was filed, it brings in the rule of judicial administration 2.420. And again, that rule has pretty much the same procedures as rule 3.220, which allows a party to file a protective order. It allows a party to ask for an in-camera inspection, and all of the things that are within rule 3.220 are also within the rule 2.420 of the rules of judicial administration. So we have the procedure, and we have a guideline from the appellate courts as to what this court can do regarding the protection of certain privacy rights, certain confidential records. I'd next like to move to the categories of items that we're talking about so that the court understands what exactly it is that we want this court to prevent disclosure of. And I've laid them out in my motion, okay? The first thing is categories. I will then move into documents within the discoverable or the release of records that should be redacted to a degree.
And before you get to that, if I could just ask, today for this presentation, are you going to focus on what's still at play in terms of you all met and you're meeting? You're still talking about things that you have not agreed upon.
Correct.
You've made all these other agreements.
Correct. And what's thrown a wrench into this is the extreme positions taken by the press. Because I reached out first to Ms. Abrat over the phone because I felt that while I didn't agree with their position that all of this stuff comes within 119, I understood that the conciliatory position of them taking in their motion, which is we're not interested in these categories of items, I thought was reasonable. So I wanted to reach out to them and say, look, if we can come up with an agreement on this. The problem that I had was that, they still felt that everything comes within 119, and I didn't want to agree to that. I didn't want to agree that all these categories of items come within 119. And then I never bothered to reach out to the Orlando Sentinel for the simple reason that their position is at the other extreme. Everything comes in. We're entitled to everything. And so, no, I did not reach out to the Orlando, but I made an attempt. We made an attempt with the state. We made an attempt with the press to try to come up with a framework that we could all work with and expedite the information that they wanted and the information that we felt could be released, and that we could then proceed with the discovery in the case, start with our depositions and things of that nature. Okay.
Thank you.
So let's look at the categories of items. The most obvious one is medical records. Mr. Ortiz is a veteran. He has gone to the VA. He has been treated for certain conditions. Those documents are in, I want to say, part 2 of the discovery. When I say part 2 of the discovery, let me explain what I'm talking about. Part 1 is the discovery that the state has in relation to either subpoena documents, search warrant documents that they have actually in their possession. Part 2 consists of electronic data, which comes from the seizure of Mr. Ortiz's computer, cell phone, and I believe another 1 or 2 hard drives, correct? So that would be part 2. Part 3, which really doesn't come into play at this point, is additional subpoenas or records or subpoenas for third parties that the state obtained after giving us part 1 and part 2. Okay, but let's focus on the categories. I think it's easier we deal with categories as opposed to, at least at this point. So the first category is medical records. They're not relevant to this case. This is not a medical malpractice case. This is not a DUI manslaughter case. This is a case where the defendant is accused of providing funds in excess or contribution, like electoral contribution in excess of the state limit. So medical records are completely irrelevant. Second, there are also medical records to Mr. Artiles' daughter, where she had an accident. And there are photographs of her partially disclothed, or for lack of a better term, disclosed, not completely naked, but disclosed, and medical records that relate to her. Has she lost her privacy right? How is that relevant to this case? Absolutely not. Even the state will admit that these medical records, whether it be from Mr. Artiles or his daughter or anybody else, completely irrelevant to this case. They're not even evidence. So that's one category of items. Second category of items. Emails. Emails related to communication between Mr. Artiles and witnesses in this case, or co-defendants. That's all fair game. That is not an issue for us. So long as the email address is partially redacted so that he doesn't get bombarded by emails from third parties. So it can be done in a way so that the press gets what they want, but at the same time, Mr. Artiles' privacy rights are protected. Same thing with his communication with his clients. His clients didn't give up their privacy right because they sent an email to Mr. Artiles, or his wife, or his children. Clients, customers, those people did not give up their rights. They have nothing to do with this case. Those emails are completely irrelevant. They're not even evidence. Emails that relate to the witnesses that the state believes are witnesses in the case and the co-defendant, yeah, that's all fair game, but we don't have an issue with that. Phone records. As I stated earlier, cell phone numbers are a form of personal identification information. People use them all the time. When they go on a website or they log in, sometimes those logins ask you for a phone number. If you registered your account with your phone number, that's a personal identification information, piece of personal identification information. So how have the courts dealt with phone numbers or phone records? Media General Operation versus Feeney, 849, Southern 2nd, 3 and at 6, First DCA, 2003. The court held that the private or personal phone calls by 5 staff employees of the Florida House of Representatives were not created or received in connection with the official business of the House and therefore fell outside the current definition of public records and were properly redacted. Here's the key, properly redacted when produced as part of a public records request. In other words, Judge, and I'll show you with the sample of documents in a minute, but those records, any phone records can be redacted. We get them all the time in federal court. You redact the first 6 numbers, the prefix number, the next 3 numbers, and you leave the last 4 numbers available. Now, here's where we have one disagreement with the state. When we met, and I'll show you, prior to the meeting, I sent an email to Mr. Vandries. Tim, what's your position on cell phone records? Well, his position, he wrote back, and have the email said, we don't redact phone records. When we met, I showed him the witness statements that he provided to me, in which in all the witness statements, the phone records were redacted. And I asked him, I said, Tim, you told me in this email, you don't redact emails. I mean, you don't redact cell phones. Look at these statements. You redacted the phone numbers. Why? I understand his response, and I actually agree with his response, which was, I wanted to protect the privacy of the witnesses. Well, that same privacy right should accrue to Mr. Artiles' family members, Mr. Artiles' friends and families that have nothing to do with this case. I don't have an issue with redacting. He actually redacted the whole number. I'm not even asking for that. I'm simply saying that there are certain privacy rights that need to be protected, and if the state is going to go out and protect their witnesses' cell phone numbers, Mr. Artiles deserves the same protection. And I'll show you in my samples what they did. I cited the Zimmerman case, which is the most recent publicity case, high publicity case. And there, and I believe the attorneys for the Herald and I both provided the court with a copy of the order that was entered in that case regarding the non-disclosure of certain categories of items. The court restricted access to phone records irrelevant to allegations stating the court has not been provided a basis to find that the defendant's cell phone records are relevant or should even be considered evidence. The person is contacted by the defendant in the days surrounding the incident should not be connected to the case merely because their telephone numbers appear on the defendant's bill. I'm going to show you a copy of the bill that the state obtained through a subpoena from Mr. Artiles, and the court will see every phone number that called Mr. Artiles and every phone number that Mr. Artiles called is on that bill. What's worse is that the bill goes back to January 2020. Criminal activity in this case is not alleged to have occurred or begun until the middle of March. And I spoke to Mr. Van der Wiesen about this, and I asked him, I said, what is the relevance of this? And his response was, which I understand, was we want to show that there was no contact between Rodriguez and Artiles prior to this March date. And my position is very simple. One, that can be resolved by way of a stipulation and or a partial redaction of the phone numbers. Again, redact the first 6 numbers, and we don't have an issue with that. But you can't just turn over a phone bill with the numbers of all the people that called Mr. Artiles or that Mr. Artiles calls for them to be hounded by either the press or any third party that wishes under 119 to have access to this information. So I'd like to walk the court through some samples.
You have a copy for
I mean,
I can't give that to the
look
press.
at? Okay, oh, so this is the thing.
Those are the samples of the discovery
I didn't
documents.
know if this was a sample of something else.
No, it's the sample of the discovery provided to me by the state.
Okay.
And that has not been filed.
Yeah, go ahead and place
If
your
I
address.
may be heard, Your
Yes,
Honor.
ma'am.
Whatever defense counsel presents to the court in open court becomes a public record right off the bat. So I would object to what he's doing if this is if this is part of the in-camera that you're talking about, but by virtue of him handing it to you in open court, in a proceeding, it becomes a judicial public record.
My position is that this is an in-camera request for review of documents. I've said that from day one. I said it when I started talking. I even said, I prefaced my statement saying I'm going to be handing the court samples that I want the court to review in camera. I don't know if counsel heard that, but I was very clear that this was a request for in-camera review pursuant to 3.220M subsection 1, and nothing has changed.
Your objection is noted for the record. It's just 10 minutes overdue.
Judge, the first document that you're going to see is a printout of photographs that were in Mr. Artiles' phone. Now, I'm sure that there is, and I talked to the state about this, there is at least one photograph there that is relevant, which is a copy of Mr. Artiles' driver's license. I talked to Ms. Solomon about this, and I think we had discussed that she would redact the driver's license number and the date of birth. So we don't have an issue with that. And according according to Mr. Van der Giesen, the reason why that's important is because there's apparently a text message between Mr. Arquiles and, if I remember correctly, Tim, right? There's a text message or something, communication where a copy of the license was forwarded to Mr. Rodriguez. That's my recollection.
Yes, Judge, this appears, Tim Van Der Giesen. Also, Judge, I forgot to announce the presence of Ms. Solomon. She is, in addition to our employment counsel, she is the foremost expert in our office on these issues. And I always say that I hope to never be an expert on public records, but Ms. Solomon is our expert, so she is present for the hearing also.
Thank you. Welcome.
Yes, Judge, as far as for the relevance of that picture, in our estimation is a picture would be, what Your Honor is looking at is either the one on the far right on the top row or the second from the left on the second row. It looks sort of similar. I don't have my evidence in front of me. We allege that Mr. Artiles sent that picture of his driver's license to Mr. Rodriguez along with a credit card, and I don't see the picture of the credit card here, to enable him to use Mr. Artiles' credit card. So like I said, the pictures are very similar, so I don't know which is which, but we extracted from Mr. Rodriguez's phone a picture similar to that one. It seems to be from Mr. Rodriguez. So some combination.
That would be
combination
I'm not an issue with
in
that.
our opinion, would be relevant to our case on, and again, now, Judge, we discussed before, I'm here for the prosecution of the case and the relevance and the 3.220 discovery. Ms. Solomon is here, we kind of divided out. She's here and can speak to more of the public records relevant to that. So it would be relevant to my case for that reason.
Okay, but everything else you've agreed is not relevant to the prosecution.
I don't, none of those other pictures that are in front of Your Honor, no, they're not relevant to our case. Like I said, I'm not even sure I've seen them because, to give Your Honor some context, we did a search warrant and see 6 items, at least 6 electronic items: cell phone, an iPad, 2 Mac Pros, a storage device, and a printer. There were 6 items. When we do our search of those items, once they're imaged by our technician, I'll call him our expert, we do a search that has to be somewhat limited to looking for what we think is relevant. So I don't even know that I've seen those on what item they came from. Some of the stuff the defense provides me wouldn't necessarily have been notable to us. So if we have it, it's because it exists on an image of something that we've obtained. And I can tell you just by looking at them, they're not relevant to my case, and I don't know where they even exist necessarily personally on the stuff that we have. So,
Which sounds like it speaks to the point, really, the heart of the matter is why that would not become public record.
again, now you've crossed the line to Ms. Solomon's expertise, and I'm
And so two notes. One, on the DL, we redact the photo, the signature, the address, and the DL, and that's under 2 different statutes. Now, once discovery is given to defense counsel, then they are subject to public record. So if Mr. Van Giesen gave the contents of any of the computers or cell phones or the printer to defense, now they're subject to public record. We don't look at what's relevant and what's not. We just look at each individual record to determine what part of that record needs to be redacted. Medical records would never go out because they're protected by HIPAA, okay, and other statutes. But like here, the only thing that I see that I would redact and thus not give to third parties, whether it be the press or a private individual, would be the DL information. I mean, just looking at this first page. Because we have to provide a statutory basis for each exemption that we make. So, for instance, the email address, there is no statutory basis for me or my attorneys to redact that information, unless they are a judge or a former judge or an ASA or Department of Corrections. If they're a normal individual, there's no statutory basis allowing me to redact that information. So I have no choice, unless the court limits what can be given out, but to get that information out.
Okay, thank you.
If I may add, and we see this more at the federal level, Tim didn't turn over necessarily the discovery part 2 items. What he did was he returned the property of Mr. Artiles back to us. In other words, the physical computer, the physical phone, the physical hard drives were returned to us, okay? What they get is, what they did was they, for lack of a better term, they cloned that information. That information is raw data, okay? And what happens is that Mr. Vanderbiesen will get, if he doesn't already have, is a report from an expert, from a computer expert, which basically uses the data to recreate the image that the data had in the original computer. So he gets a report and it gets a little link, and then you click on the link and then it gives you a picture of whatever it was that the computer was showing for that data. Okay, so they're in the process of doing it. They have not turned over those reports to us. Okay, and from those reports, people determine what, if anything, is of an evidentiary value to the state, and they have the right to do that. We're not arguing that. We are arguing that there are certain things in that data which comprise the discovery part 2, which is either confidential or personal identification information or non-relevant material that shouldn't be turned over. That's all. So that's where we're going, Judge. So we're not asking for a blanket protective order. That's not our position. Okay. So that's just an example of some things that are in there that, and the first photograph is obviously the first document is just pictures of the data that is okay. Now, if you go to the first email between myself and Mr. That's in there, not the first email, but we got discovery on April 30th. Okay, on May 11th, we're notifying the state that there are certain redactions that were done incorrectly. In other words, you could see the bank account numbers through the discovery that was provided, through the redactions that were provided to us. And we notified Mr. Vanderbiesen's office immediately to let them know that whoever was doing the redactions, use a better program to do the redactions, because you're going to have to see the account numbers. And that is clearly prohibited by 119. That's one of the categories, that one of the exemptions to 119. So if you look at the next document, this is a copy of a bank statement on a witness by the name of Wade Scales. I don't know if there is a particular transaction in here that relates to this case. If so, that does not have to be redacted, obviously, but account balances, how is that the purview of the press or anyone else? That's Mr. Scales' personal bank account. Number 2, what he pays Comcast, what he pays FP&L, what he pays on his debit card is clearly within the privacy right of Mr. Scales, and has no relevance to this case unless the state takes the position that any of these transactions are related or are evidence in this case. I don't have an issue with that. Whatever they deem as evidence, and they're the only ones that can determine that. So
Stop right there and put a pin in that. Did you all discuss this particular document in your meeting? And is there anything part of it? I know we're looking at samples here, but just it gives me a good idea of whether or not there is anything about this particular bank statement that is relevant to the prosecution.
Yeah, Judge, yes, I can't tell by looking at it if I have the entire statement or everything that goes with it, but Mr. Scales, at the behest of Mr. Artiles, withdrew, I meant to bring my last one with me, I withdrew, I believe it was $9,000, $10,000 in cash and gave it to Mr. Rodriguez. So that transaction is in the statement. Like I said, I don't think I'm looking at the whole statement, so it's hard for me to tell by looking at the transactions, which I think it's the 13,560, but I'm not an accountant, so it's being described in this record as a debit, and I don't remember if he withdrew that amount and then just gave part of it to Mr. Rodriguez, but Mr. Scales' bank account is relevant because he gave money to Rodriguez at the request of ourselves. And it would be around this time, like I said, I don't have my records in front of me, but I think it's gonna be the transaction on 11/13.
But the other stuff that looks like, okay, so Comcast, for example, or something like that, that's,
It's only one transaction.
Right, and we don't have an issue with that, Judge. If the state feels that a particular transaction on a particular date is relevant evidence to their case, they don't have to redact it. I don't have an issue with that. But every other transaction, the bank account balances, bank accounts, numbers, things of that nature, of whether it be Mr. Ortiz or anybody else, is completely irrelevant. It is not evidence. It is non-relevant material. And the press has no right to know what is the balance of a particular witness's bank account. So that's the point that I'm trying to make. Now, if you look at the next document, this is a statement from Mr. Ortiz's boat loan, where he made payments on that boat loan. To my knowledge, this whole document is completely irrelevant to this case, unless the state can come in and say, this has relevance because of this, this, and this, then I'm good. But the balance on the account, completely irrelevant. And any other transaction that doesn't go to the evidence in this case are completely non-relevant material. These are just examples, Judge. The next document over. This is a perfect example of a mistake. And it's a mistake. It wasn't done intentionally by the state. This is a document of a loan application where if you look at the top, you see ID type 1 number, that's been redacted. You see that?
yes,
Now go to ID type 2 number.
no.
I circle that. That's my circling of the document. Okay. So that's Mr. Ortiz's social security number. So my point was, and I've said this before to the state, to Solomon, Mr. Vandergeesen, that we've got to do a better job of, or they have to do a better job of redacting some of this stuff. This is not that intentional. They're overworked. I understand that. Okay. But again, as I said to the court at the beginning of one of the first hearings, we cannot afford mistakes in this case. Too high profile of a case to afford mistakes. So we've got to be a little bit more careful than we usually are on the disclosure of information in this case. Next series of documents, cell phone records. Okay. You see that I sent an email before even filing this motion, asking the state what their position is. And this is Mr. Vandergeesen's response to my email. Again, paragraph 1 talks about the raw data situation that I explained a little earlier, and that Mr. Vandergeesen explained a little earlier. But look at paragraph 2. The state's position is that cell phone numbers are not redacted. But if you go to the next document, which is just an excerpt of a witness statement, actually it's the co-defendant's statement, you will see that on the 3rd page, at page 10 at the top, line 19, 21, and 22, certain redactions were made of the witness's cell phone records. And I understand and agree with the state's desire to protect the privacy of their witnesses. I don't have an issue with that. But Mr. Ortiz deserves that privacy as well. Witnesses deserve that privacy as well. Unrelated third parties really deserve that privacy as well. So if we're going to be consistent, let's be consistent, is my point. Now, this is a side issue, and this is something the state's going to have to decide what they're going to do. They want to protect the witness's privacy, but yet they disclose the witness's address. If you look on page 4 of that same statement, which is I believe the first page, line 11, they disclosed the witness's address, which they also did in their filing in court with their discovery information. Mind you, most of these witnesses have lawyers. I think,
I see mailing address and email address.
correct.
The next.
Correct. So there's a bit of an inconsistency here, Judge, with wanting to protect the privacy of people, yet disclosing their addresses and disclosing their emails. And I have a problem with that. Those things can be redacted to the point where we protect them. We protect everyone. And the press gets what they want. They get the statement. We're not asking that the statement be redacted as to what occurred, simply the personal identification information, the ability to communicate. I think it would have been a better way to go about this was the witnesses that have lawyers, disclose them in that disclosure with care of John Smith, Esquire, and the address of the lawyer. And let whoever wants to contact that witness work through that witness's lawyer. It also, to a degree, would prevent the tampering with witnesses. We don't need witnesses in this case being harassed to the point where they're going to come into court upset or under pressure from third parties and feel they need to appease those third parties in the course of their testimony. And I'm concerned about that. I'd like to protect everybody if I can. The rest of the statements, these are just samples. The rest of the statements, Mr. De Felipe's statement, same thing. Address is disclosed, date of birth is disclosed, and yet the phone number is redacted on page 22 of that statement. Same thing with Ms. Adkins. Go to Ms. Adkins' statement. Address disclosed, emails disclosed, work number and cell phone number redacted. Mr. Orlando Rodriguez, another witness in the case, same thing. Address is disclosed, emails disclosed, account number and phone numbers are redacted. But there's a lot of information here that needs to be redacted, Ron, is my point. And the same thing with Ms. Harper's statement. Same thing, in reference to Ms. Harper. We only provided the court with a copy of the address that was disclosed. Ms. Cardenas, same thing, address disclosed, emails disclosed, and then phone numbers redacted. Okay, in fact, and this is a good thing. The state redacted not just her cell phone, they asked her for her husband's cell phone. If you look at page 16, the state redacted the husband's cell phone. Once again, Mr. Ortiz' wife is entitled to the same privacy protection as this witness's husband. Now, the court will go to the exhibit for the cell phone provider statements. Provide the court with a list of 3 samples of 3 phone bill statements. Okay? If you look on the top left side is the account number. You see that? Okay, and underneath that, you see that the phone call toll records begin in January of 2020, 2 months before the criminal activity. And once again, if the state wants to introduce these records, even though I'm sure we can stipulate to that fact, I understand that, I don't have an issue with that, but these records need to be redacted. In other words, they need to, at a minimum, redact the first 6 numbers of these records to protect the privacy of everybody that called Mr. Ortiz or everybody that Mr. Ortiz called. Granted, if they have a record of a phone call between Mr. Ortiz and the co-defendant, or Mr. Artiles and a witness in the case, that doesn't have to be redacted. In my opinion, they could just simply redact the first 6 numbers as well, and it's there. We're not going to deny the facts of what the records are showing, Your Honor. So I don't know where we're going with this, but these people need to be protected. That's my point. You go to the records of Mr. Rodriguez, different cell company. Same situation. Where there is no reason for disclosure of, you know, for example, this record appears to be a record from June 3rd, 2021. I don't know how recent this stuff is. It's at least my copy is at the top is printed June 3rd, 2021. I don't know if that is when they got it, that's when they printed it, but clearly, I'm sorry, my apologies, but that's when they got the record or when they printed this stuff, because the start date on these phone calls started also in January 2021. You see where it says start date?
Yeah.
Okay, so my point is that these people deserve their privacy as well. And if you go to the third set of phone records that we were provided with, which is Mr. Alvarado, same situation. Dates go back to January, has every phone number that called Mr. Alvarado, every phone number that Mr. Alvarado called. There's no reason for disclosure of this information as to the number in total, as opposed to a redaction of the first 6 numbers of the phone call or the phone numbers. Part 2, which is the next series, contains, and this is the first page is from Mr. Artiles's phone, actual phone, cell phone. And he has his list of contacts in that section of the phone. And one of the contacts that he has is his own contact because it contains his account information and passwords to every single account that he has. Now, I've talked to Ms. Solomon about this, and I believe if I'm not mistaken, she will speak up, but she told us that she would redact the information as to this particular contact regarding passwords and account numbers and things of that nature. So I'm not concerned about that. What I am concerned about is the other contacts that are in that phone that should not be disclosed because they're not relevant to this case, other than witnesses or Mr. Rodriguez's contact or anyone else that the state deems to be a witness in this case or evidence in this case. And even then, those contacts should be redacted to protect their privacy as well. The next document, Your Honor, is an email from the VA to Mr. Artiles discussing some medical information. Obviously, that goes within the medical records issue or the medical records category, which I believe, if I'm not mistaken, the state's position already is that anything that's medical records related would be exempt and would not come within disclosure to any third parties. Am I correct?
Well, not made it a little broader. So if you have an email, I haven't read this one, but if you have an email from the VA, that in and of itself is not exempt or confidential. Any personal identifying information regarding any illnesses or diagnoses that are within the email, like, you know, hi Tim, I have a migraine today, I can't come in, you would take out I have a migraine because that's under HIPAA. The rest of the emails would be subject to public record.
My apologies. I did not include that email. I'm sorry, I did.
The one entitled.
Yes, it's from a Mr. Rodriguez.
Right.
Okay, and obviously, Judge, medical record or medical communication regarding conditions or what a patient has to do is clearly a medical record. In other words, just because somebody in your doctor's office sends you an email and says, Judge Wolfson, you need to take this medication, or Judge Wolfson, you need to do these procedures before you come into the office. That's a medical record. You're getting medical advice, and you're getting information from a licensed physician or a licensed physician's office. That clearly comes within the definition of a medical record. This email talks about a sleep study. It talks about things that he has to do, the forms that he needs to sign. That's clearly all confidential, comes within a definition of a medical record. The next document, Your Honor, is the copy of the bill statement with the account number from AT&T. Clearly, it's personal identification information, has account numbers, it has balances, it has how much the bill is. Unless the state can find some kind of a basis to introduce a particular bill, we don't have an issue with that so long as it's redacted. That's all. The next document is a photograph of items that are contained in Mr. Artiles' computer, which, as you can read, have personal information regarding contracts, personal information, clients, personal information and business records, attorney-client communications, things of that nature. We took a photograph of it to make it easier and reduce the bulk of the sampling on it. But just to give the court an idea on the classified or the confidential or personal identification items, categories that are included within that computer. And by the way, Judge, we can always come back to discuss the discovery part 2, because they haven't turned over anything to us. Okay, so that can be dealt with down the road when Mr. Van der Giesen gets his report from his experts and decides what, if anything, is evidence in there. We can then come back. We don't have to make that decision today, so long as the state doesn't turn anything over yet. The next is a photograph of Mr. Artiles and his children that is in either the phone or the computer. I mean, this is common sense, Judge. This is not brain surgery. You don't turn over photographs of children to the press or to third parties when they're not relevant to this case. And then the last photograph, or the next photograph, is a photograph of Mr. Artiles and his family members. How is that relevant in this case? Not evidence in this case, period. And the last item, Your Honor, is a text message between Mr. Artiles and, I believe, a family member. I believe it's his daughter. So we're talking about things that are common sense, in my opinion. Those are things that are not relevant material. The press has no need for it. That does not, none of this stuff that we're asking for provides the press with knowledge of how the government is functioning, which is the purpose of 119. So all we're asking for is a common sense approach, common sense protective order to provide the state with guidance as to what they can turn over, what they cannot turn over, and the items that they are going to turn over, what redactions, if any, need to be provided. That way, they are protected. Mr. Artiles' privacy is protected. The witnesses and family members of Mr. Artiles and friends of him are protected, and the press can have all the information on the evidence that they want. That's basically our position, Judge. Not complicated. Thank you. I'm sorry to take up so much of your time.
No, you're fine. I just want to check in though, Mr. Gregg has a hearing after this, and I know you have a federal
I
court.
do, Your Honor, at 1:30, so I don't think we're going to be able to get that on mistakes.
So can I ask, do the parties think realistically that we would be done in the next 45 minutes?
I would probably defer more to them, Judge.
thought
I think
so.
I would, a few things I just want to clarify, so Your Honor has clarity on some of the factual stuff. Not that was misrepresented. I think there's a few things I could put a finer point on, so if Your Honor is more informed with the rule.
Sure.
But most of it's going to be, I think, them and any questions you have, probably from Ms. Sullivan,
Okay.
probably from myself. So
What do you think?
I think so.
45 minutes? Okay, so we could at least have testimony from the police officer.
Yeah, the only problem is, they're not doing it in person, so I have to go back to my office to be on Zoom. It depends, we don't call that turn, so.
No, yeah.
From 1:30 all the way down to 5:30.
I'm not gonna cause you any trouble with that. I just wondered if maybe, how long did it take you to get back to your office?
It would, if there's no traffic, about 20 minutes.
So if we were down here before 1,
Before 1. We could certainly, I mean, it's under an hour in case, I mean, I'm working.
Yeah. I would work with, and Ms. Minier, this is your case, right? Okay, and thank you for your indulgence for the folks we're talking to now, and thank you for your patience. Do you all prefer to try to get the officer on this morning, or do you want to come back another day this week?
Well, Judge, I mean, I have an option here as long as we can make sure his schedule is conducive. I would hate to make Mr. Gregory.
Yeah, why don't you all do this? Go out in the hall,
Yes.
have a conversation, figure out what's easiest for you, and I will accommodate you however I can.
Yeah, maybe towards the end of next week, because I have a PBH in Rockport on Friday.
Yeah,
And then I have a trial, first trial next, starting next Monday.
why don't you all talk about it, see if you can come up with something. I'm here, I'm gonna take a little bit of leave time in the middle of August, but I apologize for I think I did sort of double booked in a way. Yeah. All right. Give me 2 minutes, I'll be right back, and then we'll hear from our folks from the media.
All right.
You're right here. There's no one.
What do you think, Jamie? What do you think? Is this pretty good? I mean, that doesn't work, so it doesn't matter what, she does, you know. They're writing down stuff, it doesn't matter the word she is. What's wrong with you? Why are you so quiet today? Why are you so quiet today? What are you talking about? You're never quiet. Yeah, all you know how to do is move the cameras. People come in here and spend hours trying to set these things up, and you come and move their stuff. When they expand, you don't get second. You know what I mean by expand? Good, good. Good. Why you have such a mess of paper clips? I never seen so many paper clips on top of your desk. It's the same thing you say to too. All right.
Thank you so much. Please be seated.
Jenna, maybe we address Mr. Zelaya?
Yes, Ricardo, the buyout on the 23 and 24 again. I'm sorry for the delay today.
It's not a problem. The other, we talked, we believe if we can move this to next Thursday, 7:15, at the end of the calendar, it should, like I said, it should take less than an hour. You know, I have depositions in the afternoon. I will move those if need be.
So I have a motion to suppress already set that day.
I mean, this is a quick one, though. It's a one witness one, plus some body camera. So I don't anticipate it taking, even with argument, Your Honor. I mean, you have the case law from both sides. I mean, I don't think there's anything else. I believe we actually are, we're very close to what we believe is the law.
Okay,
It's just the actions
Okay,
that I
okay.
think are different.
we can certainly give it a try,
Yes.
right after calendar, but I will make a note for myself when things have been said, but I'll try from this point forward to keep that date light.
Yes.
So that we can, but I'm not sure who's handling the thing with Ariel from the state.
That's not mine. I have a motion to suppress 7:16. That was our first
Yeah,
choice. And
yeah,
then I
yeah,
realized,
I see that also,
Yeah.
yeah. Now, I will tell you this, the 7:16 not work at all?
It does work for me, Your Honor,
What would be
absolutely.
better for me, honestly, is to do that 7:16 at like noon or something like that. So you could do, from 10 to 11:30, the other one, and like maybe say 11:30.
Yes,
Would that work?
that's
That
fine.
helps me because the other day is a little bit disjointed. So,
Yeah.
all right, let's do 7:16. It'll print on the 9 a.m., but I'm gonna put it in my calendar for 11:30.
That's fine.
Okay?
thank you,
All
Judge.
right, so Ricardo's July at 7:16. And again,
That's okay, Your Honor.
Gus, can you make sure the corrections get to Word because they've got them, they're holding him in the back.
Can you please let them know that it's just because of the courts, because I know Mrs. Lyle is very
Yes,
eager to get into court.
I 100% will do that. I'm sorry?
What time?
Well, it's gonna print at 9, but we're gonna do the hearing at 11:30. All right, perfect. Thank you.
Thank you so much, Ron,
Thank
for
you,
your
Judge.
indulgence.
No, thank you.
There's one quick matter before.
Yeah.
I'm going to request that the court file under seal the sample documents that the court reviewed in camera.
Okay,
It's an order tennis motion this time, so it's just to protect the character of those samples and preserve them.
understood. So Jeanette, I'm gonna hand that back to you to be filed under seal.
Thank you, Judge.
Thank you. And Ms. McElroy, I've been here for just one moment.
If I may be heard on that point.
Give me just one moment. I'm putting that other case in my calendar. Yes, ma'am.
Yeah, it's just on the procedure. It's got a little awry. I believe Dana McElroy, colleague, on behalf of the media and the public's rights. Typically, something that's submitted to camera is maintained by the court in camera, but doesn't necessarily go into the court file under seal. And I think these are important distinctions. Obviously, the court would like to receive materials for in-camera inspection. The court can do so, and a notation is made, but they don't just automatically go into the file under seal. So I would just object to that particular procedure, not to you maintaining them in camera, but and they would travel along if there are any disputes. For example, you call it court proceed, but they are maintained in camera versus under seal. So
Okay, Ms. Solomon, do you have anything you want to weigh in on in reference to that, the in-camera versus under seal mechanism of the court keeping these documents?
I think it's a matter of semantics, to be quite frank with you, because at the end of the day, they don't have access to them.
So it's a distinction without a difference, essentially. Okay. And Ms. McElroy, that's what can cross my mind, but can you flesh that out for me, why that would be? I mean, I understand mechanically it's different, but what is really the difference between keeping it that way?
maybe we can just make a notation, these were submitted under, for in camera, they're being kept under seal as in camera materials.
Sure, I think that would be appropriate. So Jeanette, can you make that notation when you seal the documents? Okay, thank you. You may proceed with your argument.
Thank you, Your Honor. A couple things I wanted to just clear up right off the bat. That is that the defense motion is very broad and it has real broad brushes. It misstates some of the law on public records and what public records are and what they're not and all those things. And so the first thing that I want to try and unwind a little bit is what needs to happen in cases where we have, lots and lots of discovery that's getting turned over to the defendant and then achieves the status of a judicial public record, which is really what we're talking about here. Anything that is gathered by the state in the course of their criminal investigation is by definition a public record under Chapter 119. And so the defense's position in the cases that he cites, Clearwater, for example, are an entirely different situation. That's a situation where there is a public records request made of an agency and a court in a non-criminal context, and a court is determining, well, that's a public record or that's not for whatever various reason. Here, and I think the state would agree with me, but feel free to disagree. Here, the state has gathered particular materials. Those materials are criminal investigative information. The state withholds that typically as active criminal until at some point there's an exemption under Chapter 119 for active criminal investigative information. Until at some point the materials are turned over to the defendant, at which time they lose the active criminal exemption as a way to withhold them from the press and public.
Can I stop a little bit quicker,
Sure.
and I apologize to you, but I did want to ask a question about that. So would that be, in your estimation, by, for example, if I'm flipping through these records, which no one would purport to really know whose numbers they are, but, if the thought crosses my mind as a former prosecutor, well, I wonder if these people are really part of the investigation, and maybe there's more investigation to come from these records, but you're saying as soon as they're turned over, that active investigative portion is no longer for public records purposes.
Right. Well, exactly.
Not to say that they couldn't look into these folks or whatever, continue to do that, but it's out there. Yeah.
Well, right. And I think I'm just really getting at another really fine point, which is I think defense counsel was arguing in some respects that these aren't public records under Chapter 119, and they are public records. Now, whether or not a public record is exempt from disclosure is a whole other ballgame. And
Exempt from disclosure, or that the court could limit in some way pursuant to the rules of judicial administration.
that's correct, or under the case law. More importantly, under Barron and Lewis cases, which are built in to actually, the rules of judicial administration. Their tests are in there, which apply to court records. And so I guess I wanted to clear up that distinction. Everything received by the state attorney's office in the course of its investigation is a public record by definition under Chapter 119. Whether or not it becomes public or is disclosed is what we're here about today. So, and they claim, typically prosecutors claim, active criminal investigative exemption for all their materials that they've gathered until such time as they're turned over to the defense counsel, at which time they lose that particular exemption. There are other exemptions, as we've briefed, that apply, and I'm sure Ms. Solomon goes through those on a regular basis. We know that they do. For example, a confession, portions of a statement that are confessions, and there are any number of other exemptions. We may not always agree with the state attorney's office when they claim these exemptions because they need to be narrowly construed, limited to their purpose, not broad. And just going back real quick, access to public records is governed by Article 1, Section 24 of the Florida Constitution and Chapter 119. So there is a state constitutional right as well as a statutory right. And so here, the Clearwater case and all that stuff is really not relevant to what we're talking about here. We're talking about two ways to withhold these records. One is that an exemption applies, that the state would say, oh, this is, I mean, I believe they've already said they believe that HIPAA should apply or things like that. Confession is one that comes to mind. There's also for a murder witness, there's an exemption for that. But you can find those in 119 or other statutes that specifically reference chapter 119 and say this is a document or this is information that's confidential and exempt under chapter 119. So that's different than what I believe the defense is arguing, although it may be part of it. I think they're also arguing that for material that doesn't have a specific exemption attached to it, that under Lewis and Barron, or some combination of both, that material should not be released. Primarily, the only justification would be if you can find within those two cases by the Supreme Court a finding based on the three-part test in the Lewis case, or in Barron as well. It's also referenced privacy of third parties that are inherent in the proceeding itself. And so given that, Your Honor, we have briefed for you, we moved to intervene and we've briefed and we've said on behalf of the media companies that I'm here, that we aren't seeking things that we would not object to the redaction of bank and financial account numbers, cell phone account numbers, anything that reveals password or login information or photographs of that, any photographs depicting minors. And this is all on page 6 of our memorandum. The defendant's wife or his family or third parties that are not potential witnesses are not involved in the case. This would exclude, of course, from our point of view, photographs depicting or including the co-defendant Rodriguez, photographs without images of people, photographs of checks, notes, or other financial transactions related to this case. Because as the court knows, this is a case concerning potential election fraud, which goes to the very heart of our democracy and obviously a huge public concern. The tentacles of the case, as we can see from the publicly filed discovery list, reach farther than potentially just Mr. Artiles and Mr. Rodriguez. I'm not sure if I'm pronouncing his name correctly, but in the event, there is a lot of investigation happening as to where the money comes from that was allegedly provided to Mr. Rodriguez. And so a lot of that will be relevant in this case and should be accessible to the public within certain guidelines. Obviously, specific account numbers that we're not saying necessarily should be turned over. Those are protected in other ways generally. We're also not seeking text messages, emails, or other communications that have no nexus whatsoever to this case between the defendant and his wife, family, or clients. But we don't know what has a nexus to the case and doesn't have a nexus to the case. And so we would most likely be entitled, if publicly entitled, that information if it's turned over. But in the context of this case, it's not what we're asking for, or we don't have an objection to redacting that kind of information. We had one more, First Horizon bank records for weighed scales, which are marked as unrelated. And I believe the state has said there is some relevance to that. So we're operating in a vacuum.
Yeah.
So we can't
Well,
say.
and I've seen a snippet and I'm within a bit of the vacuum too. And I think we discussed it without me over there, but the weight scale stuff, there was, bank information but the defense is suggesting that the account numbers and anything not related to this case be redacted. It sounds like you're saying exactly the same thing, but the question then falls on the state because they're the ones who know what has to do with the case and what doesn't have to be. Something that looks totally innocuous to me or you, Ms. McElroy, might actually be the smoking gun, so to speak, because we just don't understand all of the nuance of the investigation. So in that regard, you're on the same page. From my
Correct, and we're always operating in terms of the press and public in a vacuum until we get the records themselves. And I think the important point is in that what we would ask for is that the court follow the well-accepted procedures and standards that are provided by the Florida Supreme Court in the Lewis case and in the Barron case. In the Lewis case, this court must find, in order to withhold documents or materials that aren't otherwise exempted, or there's for which there's a specific exemption in Chapter 119 or other related statutes, the court must find that such material is, the withholding of that material is necessary to prevent a serious and imminent threat to the administration of justice, that there are no alternatives other than a change of venue that would protect the defendant's right to a fair trial. And that's what the Lewis test is designed to protect, is the fair trial right. And that whether withholding the information or closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish this purpose. So when the court is looking at the material from that point of view, and the reason I'm going through a little bit of this is that the defense motion, again, is just sort of, we weren't certain what they were really asking for. And I think it's important for every piece of paper and every record that we keep the standard in mind. And it's not just sort of a, asking the court to look at everything. It's really, he has to come forward with evidence or argument to meet the standard. And it cannot rest in air. And McCrary does say that the McCrary case does say that the Lewis test applies. And if you'll look at all of the cases that we've submitted, courts uniformly use the Lewis test when looking at whether discovery material that's provided to the defendant and is not otherwise exempt should be turned over or it shouldn't. And from what I can glean from the argument, there was a lot of material that the defense counsel is not asking to be withheld. And so I'm not sure what that is. And so I was hoping we could narrow in on what he is asking to be withheld that is not otherwise exempt. I think that's the ordinary way that we would go about this. The second thing is that under the Barron case, which followed Lewis, and that's Barron versus Florida Freedom Newspapers, there is precedent for withholding information that would avoid substantial injury to third parties or to avoid substantial injury to a party, or or material that's protected by some sort of common law privacy right, not generally inherent in the specific type of proceeding. And that would be things like trade secrets or, and again, not inherent in the proceeding. So in the Barron case, that case was about a divorce proceeding. Dempsey Barron, I don't know if you remember Dempsey Barron, but he was a fairly powerful politician, and he had a divorce case. And in the divorce case, there were medical information in that case that was relevant to the separation, the alimony. And so what the court said and what he was trying to protect there was that the medical information. So it's important to understand that I'm not 100% certain that the defendant has standing really to assert privacy rights for third parties that aren't here. Basically asking for the court to protect their privacy. In the Doe case, the Post Newsweek versus Doe case, that was the Kathy Willard's case, and these were customers of a prostitution ring, and they came in and said, we're innocent third parties and our names shouldn't be disclosed. And the Florida Supreme Court eventually said that their names should, because they were, witnesses or actually there possibly involved in criminal activity. But in each situation, the court has to go through and make a finding that says, this is either protected in some way, it would hurt a third party, it impacts on the defendant's fair trial rights, with a basis to withhold. And I wasn't clear from what defense counsel said, that he wasn't asking for an overly broad protective order, and that we need to make sure that, or at least what we would ask, is that if the court reviews these records, that there not be broad statements that say, oh, well, this entire category of information should be withheld, other than the things that we're not objecting to, and that where the court finds, for example, we do not believe that the defense has made any showing necessary under the Lewis case. He's filed some newspaper articles, but there certainly is not the widespread or pervasive pretrial publicity that you would see in, for example, in the Nebraska press case, that the U.S. Supreme Court specifically said pervasive pretrial publicity is not in and of itself necessarily prejudicial. And you can see from the cases that we've cited, the Bundy case, the Rawling case, any other cases where this comes up, the Nicholas Cruz case, this is currently coming up in, and it's not just Zimmerman, it's a lot of other cases. And so publicity in and of itself is not enough. And here there isn't even the level of publicity that you find in any of those cases. We do know that some certain news organizations are paying attention, rightly, and this is an important public issue, but it's not in and of itself enough to show that there's a clear and imminent danger to a fair trial right. Second, he has not established that there are not alternatives to closure or to withholding the information short of a change of venue. The cases that are actually cited by the defendant in this memo show that the court could, for example, do individual voir dire of jurors. Have you read anything? Would that influence your can you be objective? That's one of the cases that he cites. The court said, well, that was error not to do that. It didn't say that publicity in and of itself is prejudicial, but the court has any number of mechanisms to make sure that potential jurors are not prejudiced by anything they may have seen or read. And finally, the defendant has not met his burden as it concerns the effectiveness prong of the Lewis case, because we've already seen there's an arrest affidavit, there's a search warrant, there's discovery disclosures in the file, and all those documents, which are already publicly available, regardless of whether news reporters write about them, that really lay out a lot of the basics in this case. Certainly a lot of the factual information has rightfully been made public already. And so closure of some of the information, if not all of it, would not be effective to remedy any fair trial issue. But again, not knowing exactly what's in the records, you can't really say. So I would close with, make sure I've covered every point. Unless the court has questions, I would say that the defendant has not met his burden, certainly under Lewis, to withhold records that are otherwise not exempt and that are part of this discovery that relate in any way to the case. We have said, at least my clients that I'm here representing have said they are not asking for non-relevant or otherwise personal information, which I believe that the state attorney likely would withhold anyway, but to the extent that they would not, we're not asking for those categories. But again, I would request that the court, particularly when it comes to privacy, there isn't any, and I know Ms. Rose will talk a little bit more about this. As it concerns criminal cases and public records, there is the Article 1, Section 23, for example, cited by the defense, specifically carves out and says there is no privacy right in a public record. And so there's no real privacy right in public records generally, except to the extent they're otherwise exempted. And there's no privacy rights in judicial proceedings and where these things are being decided in judicial records, except where these various tests are met. And given, I think, the lack of evidence or other bases that the court has to seal records that would otherwise be public records, that is not a basis to do so. And so I don't know if the court has questions, but I would just say that so we would ask that the court be very limited and circumspect in what it decides should, if anything, be sealed beyond what we've already said that we're not asking for. And working with the state attorney's office, who I know knows all of the other, obviously this list that we were provided, these are a list of standard exemptions that usually apply. And so whether or not they actually apply, we might take issue with, but certainly to the extent anything falls outside of this, the court has a responsibility to look at and make sure that Lewis and or Barron, those two tests have been met in order to withhold it. And so with that, unless you have any questions, I'll.
I wonder if my question is, it may be perhaps for the state, but while I still have you here at the podium, I'll give you a minute.
Sorry, Judge.
I just wanted you to be able to hear what I was saying. Now, I don't mind if you're talking. I have a question. I said, I'm not sure if it's going to ultimately be directed to you all, but, in light of much of what Ms. McElroy just indicated, it sounds to me like if you all went back to the drawing board in reference to, they're not objecting to what Mr. Quintero said in terms of redacting cell numbers, redacting email addresses, redacting bank account numbers, things of that nature. When you go back to the drawing board and make those redactions, and then we come back and discuss it once all of the agreed upon things have actually been acted on. And then, because you're, and rightly so, using words like withholding and closure, those are the types of things that I believe should make the hair on the back of the judge's neck stand up, because these are important issues that we're dealing with. We're dealing with constitutional rights. We're dealing with in the context of, alleged election violations. There's a lot of interplay here, of course. And so there's some tailoring and limiting that I think still needs to happen in my mind based upon the agreements that it seems like everyone is agreeing on. Medical records, bank numbers, cell phone numbers have nothing to do with this investigation. A person theoretically could do a public records request, and I handed it forward and go through that cell phone record and just start calling every single number on the list, and then people are getting harassed. Now that leads me to the next question, this idea of standing. We don't have any clue who these people even are. So do we have to wait until the cat's out of the bag, or somebody picks up the phone? Hello, hey, your buddy's with Frank Artillis, right? I'm sorry, who's this? And what is this in reference to? I met Mr. Artillis through whatever, and it has nothing to do with anything. So and I would look at, and I'm making a lot of comments, but this is where my mind is right now, because I do think there is a next step even before I make a full ruling on this. But the idea of the standing of his family members, would it be necessary for his wife and his children to come forward? a member of that family, I think in reference to those people, wife and children, he could raise that, so, but other people, does weigh the scales, whoever that person is, need to come forward to this board and say, hey, you need to redact my bank account number and my, because it's not ridiculous, it's Comcast, how much ever I pay to Comcast, so I have to hear from Mr. Scales to come forward. And I made this clear, this is the first of this kind that I've had, so, I guess maybe in reference to that, I would like to hear a little bit more what your point is on the standing. It sounds like you agree that Mr. Artiles could raise it on behalf of his family members, but, and yes, and if Ms. Baronis.
Yes. And I would add just one thing, is that the state attorney is, and they will know this, they are bound to provide public records where there's not an exemption. And so part of the play here is, I'm not sure we're all entitled to just agree on behalf of the public, but we can certainly limit our request.
Right.
And they then are, they have a duty under Florida statutes to turn over what is required absent a ruling by the court.
Right, and then I serve as the gatekeeper of that, yes, Ms. Song.
Yeah, I mean, there's a couple things I want to touch on. I think you intimated, and I may have misunderstood you, that we can do the redactions that have been agreed upon as well as the statutory ones, like any account number. And then what we could do is return to the court on the information that has not been redacted for the court to make a determination in camera as to, well, I think there's a privacy right here, therefore I will protect it, or there's not. Now, with regard to the nexus issue, that's not something my department does, okay? So, and the prior request was withdrawn, so we charge for labor. So I'm going to be charging them, it's going to take hours for me to redact every single bank account number, password, etc. But then if there's a nexus issue, I'm going to have to charge y'all this time, because I'm going to have to get with Tim and say what relates to the case and what doesn't, which we're fine with doing, but they need to be on notice that if the court rules that there needs to be a nexus to the case, that's going to involve quite a lot of labor and unfortunately costs, which we're entitled to recoup under 119.
Okay.
And the only other thing, Judge, is I had to leave in about 15 minutes or so.
Okay, so would it be okay if I hear from Ms. Solomon real quick and come back?
Sure, and I just have a quick comment on the nexus issue, just to kind of clarify the Sentinel's position. Whether a record is relevant isn't a prong under the Lewis test or the Barrett test. So whether a record, I know in defense counsel's motion, it talked about records being inadmissible or irrelevant. That's not something the court should be considering with respect to closure. It's looking at a record to see if it's too prejudicial, if it's graphically incriminating, it's going to seriously threaten the administration of justice. There's no alternative other than changing venue, and it's narrow enough to protect both the defense's right as well as the public's right to access. So, our position, while we agree that certain things like bank account numbers, social security numbers, medical records, we wouldn't get anyway. A lot of that is confidential either by statute or the rules of judicial administration. We're obviously not taking issue with that. But as far as determining what's relevant, that's not really something the court certainly doesn't have to engage in that judicial labor. And, we wouldn't expect the state attorneys to go about that labor as well.
And I appreciate you kind of bringing us back, because that's almost full circle to where we began discussions, however long ago it was, I don't even know. But that was one of the things that I remember saying in one of our hearings, that doesn't seem to me to be the focus. So thank you for bringing me back to the middle where we were before. So Ms. Solomon, in reference to okay, so essentially the defense claim, what's difficult in this regard to me is that you all have been very gracious with your time and you have agreed on certain things, and that's wonderful, but there's still this there's a disagreement somewhere, and it's not 1,000% clear to me where you all still fall on that disagreement. Not to say that I'm shirking away from making a decision when you disagree. That's what I do every day. But I need to figure out what the crux of it is. So if we're talking about everyone seems to be on the same page, that bank account numbers, cell phone record, well, that I guess goes to that nexus thing. So the cell phone, that would be an area I think we probably need to put on the side. Mr. Quintero, you think that all the cell numbers that don't have anything to do with this investigation should essentially be withheld from the public, right?
That is correct, Ron.
Okay,
And
yeah.
I was going to address that. I'm going to start.
And I'll let you speak.
I understand, I
Yeah.
understand. I just wanted to let you know that I want to address that, but I want to address it based on her last argument concerning standing, because the rule 3.220 does give standing to a defendant and to the state who are parties in the action to move for a protective order. And the statute is clear. It says, this is all it says.
Yeah, but I don't know if that's her point.
On a showing of good cause.
Whoever, like, for example, 786-423 is Mrs. Jones, she would have separate standing.
Additional standing, because the statute, the 3.220, the rule of procedure says, on a showing of good cause, the court shall at any time order that specified disclosures be restricted, deferred, or exempted from discovery, that certain matters not be inquired into, the scope of the deposition be limited to certain matters. It goes on, then it goes even further and says, or make such other order as is appropriate to protect a witness from harassment, unnecessary inconvenience, or invasion of privacy, including prohibiting the taking of a deposition. So within the rule, it gives the parties an avenue to come before the court to protect third parties, such as witnesses or others, and gives those parties the right to come before the court and say, I'm being harassed, judge, you need to tell me to stop. So the issue of standing is not really an issue in this case, as far as I'm concerned. It's more, what is going to be disclosed, how is it going to be disclosed, so on and so forth, and we'll deal with that. That's not, but we do need clarification from the court, because we have an issue, and part of the issue is the press cannot agree what they want. They say in one motion, oh, we don't care about these categories, and then another member of the press says, we want it all.
Well, we're gonna hear from her now, but give me 1 second, you'll be able to clarify your argument. Sure. And you'll take all the time you need. Ms. Solomon, the question I would have for you, so that you can go ahead and go about your day. When you're saying this idea of the nexus, certainly your office, not you in the role that you have, more so Mr. Vanderdeeden's role, certainly has gone through these documents, not you personally, perhaps, but the investigators, and know exactly what numbers mean something and what do not. I mean, I don't think that I would not imagine, I mean, we're not in federal court, we haven't taken the grand jury and it's all wrapped up with a fine bow, but at this stage of the game, where Vanderdeeden is sitting there scratching his head going, I wonder what that number is, or, so in that regard, if the court were to say, that everything but for, relevant information must be redacted, I don't know that would be something that would be such a painstaking process like it might otherwise be in a different type of prosecution. But let's say I do order that to be done. Who foots the bill? The defense or the lead?
No, the requester, the
Okay.
requester. And just as a matter of clarification, Tim put it well when I first called him and said, what is this discovery in this case? It is a room full of boxes, okay? So, the cell phones don't alone, or, thousands of photos. And so I have to go through each photo to determine, if anything needs to be redacted or text messages, etc. Then beyond that, once I made my redactions, what communications, what specific photos are relevant to the case, then I would need to get that information from either Tim or one of the investigators. like, perfect example. Here, this is a phone dump, so presumably these 3 photos are relevant, not the others, but I would need for them to tell me that.
Right, right. What else did you wish to place on the record before you?
Well, I mean, I think at the end of the day, the only thing that I would beg of the court is that whatever decision is made, that it is clear so that there's no confusion on then the press saying, well, no, she didn't roll on that, or yes, she rolled on that, because even though the New York Times and the Miami Herald are saying we don't necessarily want this information, that doesn't mean that the Orlando Sentinel or some other requester will say, well, that's fine and dandy, we do. So unless the court rules on cell phone numbers or email addresses, I would have to give them out to somebody who requested them, even though they said we don't want them. That makes sense.
Yeah, it does.
In other words, they don't speak for the world.
Yeah,
They
of
don't
course.
speak for themselves.
There's a lot of people who
Yeah,
really
that's,
shine.
that's why I presented my argument in the form of categories of items, because I think it's just easier for the court and for the parties to understand what categories of items are limited, what categories of items are not going to be disclosed, and what categories of items need to be redacted. That tells everybody in the world what you mean when you prepare that order. That's all.
Okay, all right, thank you. Mr. Rose.
Thank you. I just want to clarify the Sentinel's position. We're not disagreeing with what Ms. McElroy has said on behalf of her clients. All we're saying is that, the relevancy argument, I think, is sort of a red herring. It's not part of the test. And so when defense counsel is arguing about whether something is inadmissible or it's not relevant, that's not something the court should have to endeavor in determining whether something is relevant or not. That's not, as Ms. McElroy said, once that information is turned over to the defense in discovery, it becomes public record unless there's a specific exemption. And that's why, the motion was very broad, and I think we've had a little bit of clarity today as to what the defense is seeking to seal, but it's still a little unclear. But as far as, the bank account numbers, social security numbers, medical records, we're not entitled, we wouldn't get that anyway. And so we're not taking issue with that. With the phone numbers and the email addresses, I do think the rules of judicial administration would require truncated versions of those anyway. And so I don't really think that's an issue. It's more of what's left over after that. And I'm still a little uncertain as to what the defense counsel's position is on that. But I agree with Ms. McElroy that they haven't touched on the Lewis factors or the Barron factors. There hasn't been any justification for closure. And with respect to the privacy issues, I think a lot of the privacy concerns, such as the bank account records, all that is already taken care of. It's more of the photographs. And I think with the photos of his family, I do think the defense would have standing because there is a close relation between his wife and his children. But at the same time, you still have to look and see whether that particular photograph or record is not that it's relevant or not, but whether it would cause, be highly prejudicial or would cause serious and imminent threat to his fair trial rights. And keep in mind, the defense is a public official. If you Google him, you'll see photos of his family, of his kids. He had them on his, campaign materials. There are articles about him with his children and his family. Obviously, I don't know what the photos are. I know the defense counsel referenced some photographs of his daughter with some accent. We, wouldn't be seeking that, but to the extent it's just photos of him and his family, there's no reason to close that. He's arguing sort of privacy rights in a vacuum, but that's not how the court should be looking at it. With respect to the emails of clients or third parties, some of these people have been subpoenaed. They're on notice. And I would argue that the defense does not have standing on behalf of those third parties he has no relation with to argue some sort of privacy concerns. If those individuals are concerned, they can come forward. But again, that's I would argue that more in the context of these communications or text messages or emails, not necessarily the cell phone records, because again, I think, the numbers would be truncated anyway pursuant to the rules of judicial administration. So we're not as concerned with that.
And email addresses.
Correct, yes. So it's more of the substantive information. And I think that's sort of where the confusion is. Again, I'm not really sure if he's taking issue with that. I know he's mentioned the photographs, but again, I don't see how he can meet the standard. He hasn't attempted to. There are no facts that go towards those three factors. And if the court is ultimately concerned about, for example, the children, it doesn't want to release that, it can always order a very narrow remedy, which is just to blur out the children or redact, crop the children out of the photograph or something. But it doesn't mean that all of a sudden, because he's concerned about privacy, that, that would somehow trump public records. I mean, section 23 in the Florida Constitution is clear that privacy rights do not place a limit on the right of access. So that's sort of where I would like to clarify. And again, it's his burden, and it's a heavy burden to close, as the court recognizes. And I just don't think we're at that point yet.
Ms. Rose, can I ask a question, more of a practical question? So, for example, you mentioned blurring out the photos. I mean, what if they are only photos of the children? I mean, what that wouldn't make any sense, right?
Right.
Common sense, that would be say that those are not going to be, those would be subject to the order of the protective order, so to speak. Photos involving only the children.
Yeah, if your honor again thinks there's something justifying the sealing of that information, then yes. If it's only the children and you're ordering that only, the children be blurred or redacted, then yeah, I mean, I don't know what it would just be a redacted photograph, right?
I would think that the manner, and I understand your point that as a public official, they've been in things many years.
Right.
And I've been in Miami for a long time, so I've seen it myself. But I do think as a practical matter, that doesn't have to go on ad infinitum, for example. So if someone says, okay, now from this point forward, I don't necessarily want my family to be in the public eye, so to speak. So there may have been photos of, I don't know how many children he has or their ages at this moment in time, but they may have been small in some campaign photograph, from years ago, when he was in the legislature, and yet these children are now grown teenagers or, something of that nature, and doesn't want them to be seen, in the public eye anymore. So I guess that's where my thought, I get what you're saying, it's sort of not to use the phrase, the cat's out of the bag
Right.
again, but in a way, if you put yourself in the public eye, as many politicians do, they'll put really beautiful photographs of their whole family, and now to say, I don't want any of my family pictures out there, I can understand where you're coming from.
And I think that goes towards that last factor in Lewis as well, whether it's narrowly tailored. One of the things the courts look at is whether the information has already been made public, because then there's no justification for sealing something or making something secret that's already been published. And again, I don't know what the photographs are. I'm just, I don't know. But to the extent that he's concerned about his family being in the limelight, they have been for years. And so I'm not sure, certainly if the court finds justification for sealing that information, that's obviously the court's decision, but I just don't see how the standard has been met here.
Thank you.
Thank you.
Ms. McElroy, do you have anything else to add on behalf of the media portion of this? I'm going to turn it back over to Mr. Quintero then.
No, you're.
Okay, thank you.
Mr. Mayor, Secretary.
Sure.
Have to go, do you have anything else?
So I'm sure I'll think of it right when you walk out the door. Thank you.
That's great.
Nice to see you. Take care. Yes. Be back on the record.
Judge, thank you very much. I just want to go back to the standing issue because very presses missed out on the rule, okay? And I'm going to read to you part of 3.220. I read part of it before. The part I read was the L section of 3.220. I'm going to read you M, the M section, specifically M1. Any person may move for an order denying or regulating disclosure of sensitive matters. The court may consider the matters contained in the motion in camera. Subsection 1, subsection 3. A record shall be made of proceedings authorized under this subdivision if the court enters an order granting relief after an in-camera inspection or ex parte showing, the entire record of the proceeding shall be sealed and preserved and made available for the appellate court in the event of an appeal. In other words, my request earlier, as opposed to their position that we were using the wrong procedure, was right on the money. In other words, the rule requires that the court seal the ex parte or the in-camera documents that were provided by the court. I want to clear that up first.
Okay, well, that was done. So that's.
Now, in relation to the reference to Mr. Martinez being a public official, first of all, he's not a public official. He was at one point in time a public official. He is a private citizen. I don't know, because I'm not an expert in that field, whether because you're a public official one time in your life, you already become a public person or a public, what do they call it, public party or public,
Entity.
and you lose your privacy. I don't think that is the case.
No, but I think there is a distinction, right? There's, okay, so, you know, Joe Plummer, who goes to work and comes home day to day, every day, you
Sure.
know, is a different type of person than Frank Artillis, who was in the state legislature and did all of that. And then is now a private citizen, no doubt about it. So I think that's really where I'm looking at it.
That's
But
fine, that's fine, and you're correct.
I agree with you in essence, that doesn't necessarily have to continue on, but, you know, we're not that far afield. Mr. Artillis is along the tooth, you know, he's, you know, got a long life ahead of him, you know, so it's not been that long ago that this was in the forefront.
Correct, and when it's one of the points in regarding the photographs that I discussed with the state, I've been advised by Ms. Solomon that if they were to disclose those photographs, or you would order the disclosure of those photographs, the faces of the children would be basically blocked out. Okay?
Anyway, regardless of what I.
That's what I've been advised, and I don't know if Mr. Vandergeesen remembers that conversation, but I think that's what she said, that she would block out the faces of the children. So I think, I mean, I would ask the court just as a matter of protection to include that in your order, but that's what I was advised by Ms. Solomon. She's been very clear, very nice to us as far as explaining what the state's position is on this matter. But I want to get back to the Lewis-Barron test. There are two different tests applied two different ways by the courts. Okay, Lewis was decided in 1982, and Lewis dealt with the closure of evidence in a case, and it asks the court to balance the fundamental interests of both the right to a fair trial and the right to a free press. However, Barron dealt with a completely different issue. And the Supreme Court in 1992, and Barron was decided, I believe, in 88, a few years later, but the Supreme Court of Florida basically discussed both cases in a decision in 1992 called Post Newsweek Stations, Florida Inc. versus Dell at 612 Southern Second, 549, specifically at 552, the court makes this comment. It declined to analyze the access to pretrial discovery materials using the Lewis test, stating that the Lewis test does not address the impact of public disclosure on a third party's right of privacy. The third parties involved were not charged with a crime, and that the Lewis test dealt with closure of a pretrial hearing, not the closure of pretrial discovery documents. Instead, the court applied the standard from Barron, which dealt in a civil dissolution case. And in Barron, the court said the following, in this case, quoted from Barron, saying, the court also noted that the public does not have an absolute right to all discovery materials, stating that, quote, discovery is not intended to be a vehicle for the media to use in its search for newsworthy information, but instead to narrow the issues of the case, to ascertain facts that will be relevant at trial, and to avail the parties of information that will avoid surprise tactics in the court. So the Supreme Court has been clear, and by the way, 119, the language in 119 says the following. Nothing in this chapter shall be construed to exempt from 119.07 subsection 1 a public record that was made a part of a court file and that is not specifically closed by order of the court. So within 119, the legislature envisioned that a court had the authority to step in and say, hey, wait a minute. Guess what? This does not have to be disclosed. And again, any party under the rule of criminal procedure has the right to come in and ask for protection from disclosure of sensitive materials. Any party. Now, Mr. Ortiz has the right to not only seek to protect his privacy, the privacy of his family, but also the rights of his clients and his third parties who dealt with Mr. Ortiz, and again, have nothing to do with this case. So all we're asking for is a common sense approach. And granted, the state is the one that's going to determine what is relevant. It's not going to be this court, and it's not going to be me, and it's clearly not going to be the press. They're the ones that have got to determine what is relevant. And we're not waiving our argument about what is relevant. We just need to know what the state determines is relevant, and then we can come back if necessary and argue about that. But there are clearly categories of items or categories of materials that this court can rule on today and say, wait a minute, that's not fair game. That has nothing to do with the case. The state's acknowledged it has nothing to do with the case. And those items either not be disclosed, or if they're going to be disclosed, they have to be redacted to protect the privacy of third parties or Mr. Ortiz, his family members. That's all we're asking for. So that's pretty much it, Judge.
Mr. Vanderbilt?
Thank you, Judge.
Oh, I'm sorry, one more thing, notice. Mr. Guillaume will kill me if I don't say this.
We don't want any murders in this program right now.
Yeah, we've been working together for 30 years. We've been working together for 30 years. Every time I miss something in court, he bopped me in the head the way I told you to say
Oh,
it.
so that is-
That's the way it works. Anyway, there is a provision in the Florida statutes that deal with medical records that require the requesting party for access to those records to provide notice and get a waiver from the person whose medical records they want in order for them to even get those medical records. So there is in place already a procedure for someone to get access to somebody's medical records, and they have to provide notice. They have to provide that person an opportunity to be heard, and that person has the right to come in and basically protect themselves from disclosure of their medical records. So if they want that, they let them go through the process of notifying the parties and everybody associated with the medical records that they want.
Very good. Thank you. Mr. Van Dusen?
Thank you, Judge. I want to clarify, just so Your Honor, I realize that to some extent, I'm the only person in the room that really knows about everything that we're talking about. You know, the court has not had a chance, obviously, to review every piece of evidence, everything that we gather as part of our case, whether somebody in this room says it's relevant or not. My opinion would be the only one that could be offered because I'm the only one that knows it. But ultimately, the court will decide in a trial what comes in as relevant material. So I understand that some of these things are being represented or because people don't have full knowledge. And so I just want to correct some things, not because I think people were intentionally misrepresenting them, but because I want to make sure your honor is clear as to what's being said. In addition to returning the electronic devices that were taken from Mr. Artilis during the search warrant, the defense was also provided copies of the images of the iPhone and of the iPad. And that's relevant because the defense made the argument that they were only given back the items. They weren't actually given the image that the state has obtained, because the discussion has been had today as to whether or not when the state turns it over to defense, then it becomes public record. Well, the state did turn over, not only just return the devices, we also gave the images that we obtained as part of our process. In discovery, we gave the images to Artilis' defense counsel of the iPhone and the iPad. And they,
Go ahead.
no, go ahead, please, Judge.
So as it stands right now, if a public record was initiated to the state attorney's office, all of those photographs, if the court doesn't limit it in some way, would be.
If it doesn't meet an exemption, as better understood by.
Right, and Solomon and.
Yeah, and by the experts in that. So the answer is not necessarily, but so one of the complications, and which is going to get to my suggestion, is that because I'm the only one because I have the most knowledge about everything we're talking about, and I haven't been through all the iPhones and the iPads, I could never do it. It's not even humanly possible. Any of us has more data on there than any other people could actually search. We do keyword searches. We look for things that we to determine are, I hate to use this phrase, relevant to our investigation. So I've never seen the photos that I saw today because we weren't necessarily looking for photos of family. I don't even know how many kids Mr. Artilis has. I don't know their ages. None of that, I agree, is relevant to my case. But what I would say today is I think that the court and the state and counsel for the media or anybody else who requested is in sort of a bad spot, because defense counsel is arguing for certain things to be protected without specifically saying this page, this page, this page. We've seen examples of what they want, but I think really the burden is on the defense to proffer for the court the exact items, like they did with the phone records or like they did with the photos today. I think beyond that, the court can't really make a ruling that's going to satisfy any of these laws, because the court doesn't really know what the defense, and I think other counsel have spoken to this, we don't know exactly what they're asking to be withheld. They can say family photos. Okay, well, honestly, I don't know what his kids look like. If you gave me a picture with 8 kids in it, I couldn't tell you what we would have to redact because I don't have any idea how many he has or who they are. I don't know who his other family members are. So we're all sort of in a pickle here with them saying, well, if there's 1,000 pictures of family members, redact them. And I'm like, I don't know which his family members are. I know the people that are involved in our investigation, and I could say they're not those folks, but I couldn't safely say to the media or to the public that it falls under an exception because I don't know who they are. And so I think the burden needs to go, instead of Mr. Quintero and his colleagues saying the state should determine relevance, I think they should present to the court, Judge, here are 1,000 pages of things, or 200 pages, or 50 pages of what we think should not be public record, should not be turned over in discovery. And your honor can decide specifically on the items that they are identifying. As it pertains to what Mr. Quintero describes as sort of the first phase of discovery, that stuff's a little easier for us because it was stuff that we obtained, as Mr. Quintero rightfully said, mostly through like subpoena, through witness interviews. So those are a little less like abstract and unknown. They're a little more tangible because we have a transcript, and Mr. Quintero pointed out. I can identify stuff in there that may be more relevant than others to my prosecution, stuff that I may seek to admit. But when it comes to, as has been described as sort of the second phase of discovery, which is all the stuff from the electronic devices, without them specifically identifying things for the court and for the state, I don't have the resources or the time or the knowledge to go through and make sure that if your honor said, okay, redact everything that's relevant to, that pertains to his family, and redact everything that pertains to this or that, I wouldn't necessarily even have the knowledge to be able to do that. And certainly the time would be
Right,
overwhelming.
if I said you need to redact, Mrs. Artelis's phone number, what is that?
Yeah, I mean, I could probably find it, but I couldn't tell you how many times it exists on an iPhone. I couldn't tell you how many times, because when we do it,
On a record?
yeah, I mean, I could tell you on a hard copy record, I could do a search of it and we could redact it. I don't want to say that on the phone records, we couldn't do that. But on, it's say, listen, if there are any records that exist from the iPhone dump, for the iPhone image, any numbers pertaining to his family, I couldn't even practically tell you how to begin to do that. So I think it's really the defense's burden to get that information, the specific information, present it to the court, and your honor can look at it and say, okay, on this page and this folder or whatever, this is going to be redacted. Otherwise, I think that the court's kind of in an impossible position to make just a blanket order, because it would be hard to apply it to the evidence. And it's,
Well, you definitely have solidified why, I feel as if my brain is
Yeah.
not working properly, because there are certain things, but that's why I keep going back to the things that you agree on, because it's easy and it doesn't even require a ruling by the court, quite honestly. I'm keeping a list here, medical, basically any and all medical records. This is
Nobody
not, that's
disagrees.
an exemption anyway. So that's, I can order that right now, but I wouldn't need to, because that's already an exemption. I would even say photographs of minors. You have indicated you don't know who his kids are or whatever. Minors, period. They could be his neighbor's kids, whoever, minors. That
Yeah,
would be
that's
very simple.
not relevant whatsoever to the case, and I think it meets an exemption. I would defer to the experts on that, but that's not an issue for us either.
Right.
I'm assuming not for the.
The other areas, email addresses and bank account numbers. But I have just a snippet, that sample you gave me in camera. It was an in camera, but it really, we're all in open court here and it was all being discussed, so it's not any secret as to what we're talking about within that in camera, but there were some bank records, this Wade Scales, who now has become, a celebrity for this hearing today, but it's a person and we can attach a name to him. His bank records, I could say, well, in that regard, a bank account number probably should be redacted. An email address in the statements that were provided to me should be redacted.
I don't know, just now you're going into public records. I can't, Ms. Solomon is the expert in that. I'm not going to step on the toes of the public.
Yeah,
I would not need to
they
read
didn't
it.
even agree to it.
Okay, I wasn't.
The public represented in the form that we have here today have agreed to email address and cell numbers being redacted to the truncated version. But where it does become more difficult, and I do agree, and I think that Ms. McElroy and Ms. Rome agree with the students who can Carol, is that there's this whole bevy of information that I do not have to be able to make an appropriate ruling that is going to put the world on notice as to really anything at this point. So, like I said, any of the discovery that we have so far, those items that I have just said, I'm prepared to make an order at this point. Much of it is part of an exemption anyway, so it doesn't really matter. But then phase 2 of this would be once that is all done, then I think it is true. You would have to come back with specificity in reference to each and every document that you believe a protective order should be granted on, and then I would in turn, make a rule. What I will say is that where we are right now, really where we've been from day one of this conversation, there's been a lot of reference to the cases, and really everybody sort of agrees to the universe of cases that apply in statutes and things. We may have different interpretations about it, but there is a relatively closed universe of cases that apply to this situation. But my focus has always been, whether it was my own focus coming in or I was led to that point, to sort of this idea of keeping the private things private that don't have anything to do with anything. So people couldn't be harassed and move aside to the rules and what intimidating witnesses or third parties. That's where I'm at. Where I am not is anywhere near thinking Mr. Artelis is to be deprived of a fair trial in reference to what we're discussing. I don't, and then you haven't argued it much other than referencing it in the motion. So I don't think we're anywhere near the realm of that. So where does that put us? Is the question.
Well, the problem isn't that at this point, we don't know, but I can show you an example of what is coming down the pike. If you take a look at my supplemental exhibit that was filed on May 28th, 2021, and this is what I'm concerned about. One of the things that I'm concerned about, the Orlando Sentinel, the caption of the article is that former state senator accused of paying ghost candidate asked judge to seal evidence from public. It's not our position, never been our position. So the very people that are asking for disclosure of information, at least one of the parties, is coming before this court with somewhat of unclean hands because it is presenting a narrative to the public which is completely untrue. On the contrary, we want the evidence in this case to be shared with the press and the public because a lot of the witness statements favor us. So we have never taken the position that the evidence in the case should not be disclosed to whether it is press or other third parties who make a 119 request for such information. I am concerned, two things. Number one, and both situations are not mutually exclusive. In other words, I don't need to prove that my client is going to get a unfair trial in order to get a protective order to protect my client's privacy or protect the privacy of third parties. They're not mutually exclusive and they don't have to be both put together. It could be either or situation or both situations. Right now, based on what I'm seeing or what we're seeing as it relates to the discovery, we are simply trying to protect the privacy of Mr. Ortiz under the rule, the privacy of third parties and witnesses under the rule. That is all. It is a limited, and the motion is captured as a limited motion for limited protective order. That's all we're seeking at this time. I disagree with the state when they want to put the onus on us to describe what documents we don't want to be disclosed, because I think they first have to decide in the part two of the discovery. In other words, the computers, the phones, whatever, the data. And what we got was the data. We got a copy of the data, we got our computers back. That's what we got. The data is unusable, you can't read it, okay? Unless you have those reports that he's talking about that provide the image of the document, and then you can click the link, and then you get the image. We don't have copies of those reports yet, because I don't even think they're done with them yet at this point. But anyway,
Well, I obviously can't take a rule on.
my point, and that's why I said that they have to come back in regards to part two. But Mr. Vandergeest is the one that's got to decide from that evidence or from those materials, what evidence he is going to use. Everything else would be irrelevant. Everything else would be subject to a protective order. That's all. So why are we going to go through thousands and thousands of pages printed, 10, 20,000 pages? I fill your courtroom with boxes of stuff asking you to review it. By the time it takes you to review that, we're going to be in 2023 with your schedule, with how busy the courts are now.
Maybe another judge who comes in.
No, absolutely not. We're not letting you go. Wherever you go, we're asking you to keep the case. So, but my point is this, that it's just easier. It's more efficient to have the state go through those materials at their leisure, at their time. And once he decides what material from the part two of the discovery is relevant material that he intends to use as evidence, then everything else can be discarded. You don't have to go through that process. So it's easier once they decide what is relevant. They're the ones that have got to decide what is relevant. Once they decide that, then I can come in and say, okay, Judge, everything else, give me a protective order on it. This cannot be disclosed. This has nothing to do with the case. So it's up to him. It's not up to us, because otherwise we're going to be fighting for documents and, for how long? Months and months. Well, this document, well, I haven't made a decision on that document yet. Therefore, Judge, you can't decide now. You got to wait. So it's on him. He's the one's got to decide. And once he decides, we can go from there.
Mr. Rand, the reason I saw you perusing some things, did you need to add anything?
No, I think we're actually going in circles now because we went from all agreeing that relevance wasn't the standard to back to that argument. So I think I've said.
Okay, so here's what here's how I'd like to proceed, at least for right now. Mr. Quintero, I would like for you to draft a proposed order granting in part your motion for protective order and utilizing any and all medical records,
Hold on, I want to write this down. Medical records,
any and all photographs of minors,
photos of minors,
and the following items must be redacted.
and the what?
Following items must be redacted.
Okay, wait a minute, redaction.
Email addresses,
Judge, hold on for a second. Redaction. Email addresses,
cell phone numbers,
cell phone numbers,
and bank account numbers.
bank account numbers. What about balances of bank statements? The balances of,
Not as of right now. The substance of those records, I'm not inclined to have.
okay. And
Now, that is, of course, unless something, this isn't making sense, but something absolutely out left field has come up. I mean, the fact that somebody paid $35 to contact each month, even though it may not be, again, relevant to anything, it's not going to prejudice or harm or cause somebody to be harassed.
what about somebody having $90,000 in their bank account?
Well, that's a whole other story, but that I'm not gonna go through the substantive parts of the records of this.
Okay.
And obviously you later.
So we've got, I just want to be sure, Judge, we have email addresses, cell phone numbers, bank account numbers. What else?
Sorry, somebody said something.
I'm sorry?
I thought I heard somebody say something.
About text messages between Mr. Ortiz and his family members?
So that's. I mean, the one that you showed me has a name of a person. You said that this is his dog. Okay, so it's not just a phone number.
Right.
Um,
See, the way it works, Judge, is remember, when you look at your text messages,
Yeah,
if
yeah.
you've got somebody on your contact, it's going to
Yeah,
show up
yeah,
usually with either their
Right.
name or their initial, depending on how you stored that information.
Right, yeah, available does, it's gonna come up, yeah. But the question though is, if we say it in that way, Mr. Andrews, this may be out to you, the practical aspect of talking about Mr. Ortiz's family members. We're talking about his second cousin, twice removed, who lives in Oregon, or, what I mean, family members is family members. You would have to we would have to, at least, if we're talking about minors, it would have to be, the first name of the one that I saw was a B, B.A., a
Right.
minor, something like that.
I can provide the initials in the court order of Mr. Ortiz's children and his wife.
I mean, that's, any and all of that information would be privileged anyway, in some capacity. So, yeah, you can go ahead and do that. But we're talking about immediate family.
Yeah,
Just to clarify, you're
Yes, ma'am.
saying text messages between Mr. Ortiz and his daughter?
Yes.
Or wife?
Yes,
And with the,
daughter, she's got 2 daughters.
okay, so 2 daughters and wife, and none of that relates at all to the case?
Communications between the spouses would be privileged.
That's what I was saying. And then,
With the children, that is nothing. I don't know if they're both minors.
No. I mean,
Both-
you know,
both-
what I looked
think
at
One's turning 18, I believe, right? No, they're still, they're both still under the age of
They have
18.
nothing to do with it. The children have nothing to do with the case. Nor am I aware of any communications that would involve this.
no, I mean, the one that was provided is, the person said, I'm bored at school and I'll see you at home, you know, something like that.
I just wanted to clarify, so we're redacting the substance of those text messages or just the names? So it would be the initial as opposed to like.
Well, the wife is precluded completely because it's privileged. They
Right,
can't be
right,
turned over.
I'm talking about the children.
The answer is yes, the substance in its
Okay.
entirety. If we're talking about children, so.
And then with respect to the email addresses and cell phone numbers, we're doing the truncated version.
Yes,
right? Okay.
Yeah.
Just want to be sure. The bank accounts would be completely
Redacted,
redacted,
Yeah.
but the email addresses and phone numbers are truncated.
truncated,
Okay.
yes. So you can put that, Mr. Quintero. Email and cell truncated bank accounts redacted in their entirety. But the substance of any of those,
So will the cells be like the last 4 digits or something like that? Okay.
What about the contacts, the contact list of Mr. Artigas' cell phone? I showed you a sample of what was in at least one contact. I know the state will redact what I gave you from passwords, they'll redact the passwords and the account numbers there. What about other contacts in Mr. Artigas' cell phone that contain his clients, his customer information?
So if I could advise the court a little bit on that.
yeah,
So Mr. Artigas is I don't know how he characterizes himself, as some sort of a consultant. He works or has consulted with various organizations, some of which relate to this case, some of which we're still tracking down to figure out what their relationship is to this case. His contacts are relevant. Whether or not every single one of them, or I'd have to go through, it's sort of like the phone records, as I explained to defense counsel when they came in. The phone records go back to January, and they said, what's the relevance of that? And I said, well, the relevance is that he didn't start talking to Alex Rodriguez, the co-defendant, until May, when they started the scheme. So it's relevant to the fact that they weren't talking for 5 months, because the defense would be, oh, no, they're friends. The contacts, in addition to some of them being very relevant because they're people that pay Frank Artigas money, and I'm talking about political organizations that were paying him money while this was all going on, those would be relevant. And
but still in all, again, it looks like a too far field with the relevant. I assumed what you were saying. What you're saying right now, it's not surprising to me. Common sense.
Yeah.
But the phone numbers would be redacted and they would be truncated. So it might say
Oh.
Tim Vandergeesen on the contact, but the cell number itself will be truncated. So
And-
to
and
the
again-
extent that people's names.
Correct,
no.
and again, we have no issue with any contact that Mr. Vandergeesen believes is relevant or evidence in this case, okay? We have no issue with that. It's the other, he has 4,000 contacts. Okay, he's talking
Their
about maybe.
names are all gonna.
Yeah,
be
yeah,
accountable.
yeah,
That's
exactly.
gonna happen, but their phone, and nobody's gonna be able to do what I laid out.
Perfect,
Call them and be like,
Perfect.
hey,
So all cell phone numbers or phone numbers redacted.
correct. Yeah, all need that.
From his contact list.
But the
We just-
names are not gonna be.
No, if I may, the cost becomes, what happens when you do this, what he's asking for, is that, is what Ms. Solomon brought up, it becomes cost prohibitive at this point for the public's right of access. And so this, maybe this is one that we can, I don't know if it's gonna bear the cost of this, is the thing.
The statute's clear. They're the requester, they bear the cost. And you know what? It's not our fault.
It's a public record that he's asking for the court to, to protect. and
The
seal.
statute is clear. It's the requester that pays for the redactions.
So but the third part.
could I propose something, Judge? You're asking for a proposed order.
Mhm.
could I suggest that we take what you ask the defendants to propose, have them submit a proposed order, and then maybe give the opportunity for another argument on that if they think, you know, once a proposed order is submitted, letting everybody see it before the court signs off on it, or before, if the court has changes you want to make, and then allowing time for people to come in then and address the proposed order, because we could sit here for, you know, all week and go back and forth on every little thing. If
And
you're
this
not,
won't be the last time.
right, and if your honor has an idea in your head as to what you think your ruling is going to be, if they submit something proposed, give everybody the opportunity to see what it is. Ms. Solomon's not here, and I've
Yeah.
admitted completely, I'm not the expert in public records, and that would allow counsel also to maybe come back and make another motion, or to ask to be reheard on something particular to the ruling, because we know what we sort of hear that the agreement is, but, you know, they may look at it after they see it in writing and say, wait a minute, this issue, like they just proposed, is going to be an issue. Would that be reasonable?
Never occurred to me. I would never, and I think you know that, because I think you know the judge, to prepare an order, submit it to the court without providing it to Mr. Vanderweeks and the parties that you
Oh,
allow.
no, I don't think that's the issue. I think he's asking if I would, instead of just receiving the proposed order, make my own determination on it without having you all weigh in again. You know, I mean, nobody would ever think that you would provide it to everybody. But the
Well,
question is, am I gonna listen to you again?
The way I would do it is I would send the document in Word.
Yeah.
And that way the court could modify it, or the court wants to bring us back in, or any party has any issue that needs to bring to the court's attention, we can always come back. That's not a problem. The court could send an email, as you've been communicating with us, saying, you know, I received this. If anybody has any issues with this, you have 10 days to file some kind of document advising, and we'll send it or something along
That's
those lines.
likely what I will do. So that's the matter. And perhaps nobody would have anything to say at that point. You can hear?
He wants to talk finally, Judge.
No, Judge, just very simply, I think it may be wise to just table this issue with the order, proposed order. The reason for that is we would like to get enough time to read a recent opinion by the U.S. Supreme Court that came out. And that was an issue about dark money that was decided, I think, last week by the U.S. Supreme Court. And it was decided based upon a First Amendment right that the organizations that were given money had the right to keep their identity concealed, even though they gave the money based upon their First Amendment right. And so I was thinking that possibly the organizations that were dealing with Mr. Artiles in this case also have a right as well under the First Amendment to deal with Mr. Artiles in political matters, which was the issue in the U.S. Supreme Court case. They also have a right, or may have a right, subject to us reading that opinion to see if they do have such a right.
Meaning to, and not to interrupt you, but meaning to come forward to this court and
Yes.
say, I don't want my name on anything.
That's right. That's right. In other words, the issue here, and I heard the lawyers for the press before mentioned that Mr. Quintero should not be, didn't have the standing to protect the rights of those third parties, that those third parties would have to come up and assert their own rights. But for those parties to assert their own rights, they have to have notice. And that's
They
what,
wouldn't have a clue.
right?
9,000 contacts, you say, or something like that?
4,000, over
How
4,000.
would anyone ever know?
Judge, actually, they know. They all
Oh,
know.
they do?
Oh, yeah.
Well, that's an assumption that they would know. I mean, look, the bottom line is on issues.
Are you saying that because they've all been contacted in reference to the investigation?
Yeah, their names are in the discovery. Alex Alvarado, the other person whose phone records that was
Thousands
mentioned
of
today.
contacts names are in the discovery?
I'm sorry?
The thousands that they're saying?
No, but I know the people that were paying Frank Artiles, and I know that they are aware from us. They are aware of the litigation, and they
Of
are
course they
perfectly
are.
aware.
But what about Artiles' electrician that he's got in his
No,
contacts?
I'm sorry, Mr. Quinones was talking about other political organizations, as to whether or not they would know that they had the right to come in and move the court to keep their contact with Mr. Artiles private. So, to give your honor, just. a
What
little-
about the more mundane fellow, that is a handyman and he's in the phone or something, and his name becomes out there as an associate of someone who's accused of a crime that's being prosecuted by the state of Florida?
Correct. It's exactly the point.
I'm sorry, I heard that the point was about dark money and about whether or not the people giving to Mr. Artiles.
That's one of the points. I mean,
That's what I thought Mr. Quinones said, and I happen to know the people,
But
the
there's
full.
no doubt that there's people though.
Right.
obviously.
Okay, that's what I thought, because he mentioned the Supreme Court dark money case, which I'm familiar with, all the logistics of dark money, because it has come up quite a bit in this investigation. And they not only are aware of, many of them have lawyers, and I've had contact with their lawyers. So I understand your honor's point. I didn't understand that that's what Mr. Quinones was saying. There was.
Maybe
I was not
should have
referring-
called and
I was-
send further yards with it.
I was not referring particularly to those involved in this case. Obviously, those organizations that dealt with Mr. Artiles and paid him money, they know about it. I mean, there's no issue about that. So I wasn't really referring about those in particular. There may be other organizations that in the past dealt with Mr. Artiles that had nothing to do with this election cycle involved, and maybe they don't want their name to come up, and they had nothing to do with this election cycle. Could have been in prior cycles, to give you an example. It could be other individuals, like the electrician that the judge mentioned, other individuals that deal with them, or other individuals that may have hired Mr. Artiles for other purposes in the past. They have the right to have notice, because otherwise they cannot come in and assert their rights here. Now, to give you an example, and Mr. Quintero mentioned it before, in the health medical field, the statute is 456.057 says that, the patients have a right to come in and intervene before you give their medical records in a case. Okay?
Nobody's disagreeing on the medical records. I'm not sure
No,
why-
but I'm bringing that as an example that the law puts the burden upon whoever is requesting the record to notify that patient. There's a requirement of notice here is where I'm going at.
So, and that's what you said earlier.
Right, yeah.
But what more notice could ever be provided than, I'm live streaming on YouTube right now, so, I don't know what more could ever be done.
Are they suggesting that we have to send out, a letter to all of his contacts to let them know, how far
That
somebody's.
cannot be the standard.
Right.
Well,
like,
that is the standard for 456.057.
Agreed.
On a patient, you have to send them a letter saying, look, there's a case involved, your medical records are in play, and now you have a right within the next, I forget the number of days, to come in and intervene.
I agree with you, that's totally unique, and in my opinion, things totally out here. So here's what I still want the proposed order. Read and synthesize the case that you wish, if that affects in some way, what we're talking about. Send it in. How long do you think it's going to take you to put it together? A week?
Yeah, that's fine.
A week is fine.
Okay. And then everyone will be noticed via email. If anybody wishes to have another hearing on it, we can. If everyone is satisfied that the court can make a ruling based upon what we've already heard, meaning there's nothing new that will come about, other than you've already made the record as to the cost. You probably don't even have a single clue how much that would cost.
I have no idea, Judge.
I would like, Your Honor, if it's okay with the court and the press, to put in the order that they have stipulated to this court that they're not interested in. So that way we have at least a framework to work from.
Just prepare the proposed order as if the court is making its order.
Okay.
I've heard the arguments of the parties and I'm prepared to make a ruling based on what I just said.
Okay.
I've already intimated, I know we're not going to be done. It's not the finalization of this conversation.
Yes, ma'am.
Ms. Norman?
Your Honor, just have one other point with respect to the proposed order. With respect to the, other documents, I'm still not clear that they're seeking closure of. Is there going to be, usually when we have these types of orders where the court says you need to go back and specify what exactly it is you want, what page, are you giving them a certain time to do that? Usually, we try to do it as quickly as possible. They've had this discovery since April 30th, and we've been waiting quite a while for this. So if Your Honor could add some kind of time restraint on them to, bring forth whatever other concerns they have with the remaining discovery they currently have.
Well, and I appreciate where you're coming from. I don't think anybody wants this to start moving along more than these folks do, because they've got to start doing discovery depositions and things like that, and start till it's going to wait years for this to.
Not only that, Your Honor, as you've seen from the emails that I provided to the court in camera, we moved beyond quickly. We got discovery on April 30th. My first email to Mr. Vanderdeesen went out, I think, on May 6th, followed by another email on May 11th. So we've been in communication throughout this whole process to try to come up with a working formula for all this. That's number one. Number two, we're not a state agency. We're not required to give anything up. It's the state that has that obligation, and we're trying to make sure that whatever framework this court imposes in its order is a framework that we can all work with, because they're not the only members of the press that are going to be coming before the court asking for information. We need to have something in place.
In the proposed order, I think it would be appropriate to say any and all future motions for protective order must be made within 10 days of receiving the state's discovery.
Okay.
Yes, ma'am.
Thank you, Your Honor. And also, the court has narrowly ruled that these particular items are going to be withheld, if I understand it.
Some withheld, some
Right, and the
redacted.
rest,
Yes.
though, is it not, should be immediately turned over?
Yes.
Okay, so that's the only thing we don't need to wait on these particular items for whatever else may be in that discovery. For example, we've talked about statements or other things that are already there.
I don't
And
see
so
any reason why.
that would be important to our clients, Your Honor, that whatever is not covered by this order be immediately turned over.
Can we
That can
get,
happen as of right now, as far as I'm concerned.
can we get 20 days instead of 10, only because the next 30 days, federal court is really going to kick into gear. And I've got 10 cases that are set for trial. Obviously, not all of them are going to go, but I know 2 of them are definitely going to be going back to back. So I may need a little bit more time. Is 20 days okay, Judge?
I'm gonna give you. I'm gonna split the baby a little bit and give you until the 23rd of July.
No, I'm talking about the future orders, any future
Oh, I
motions.
thought you meant to.
No, I'll have the order to
Okay.
you within a week. This is not a problem.
Yeah, that's fine. 15 days.
15 days, okay.
yeah. You understand what he was asking for future, yeah, I misunderstood. Judge.
From receipt of state discovery.
Correct.
Very well.
You can provide that via email to everyone here.
No.
And then we'll go from there. Okay?
Very well.
All right, anything for Mr. Quintero?
Thank you, Judge. I'm good.
Thank you.
Good to see you. Thank you very much for your time.
Thank you, Judge. Pleasure. Appreciate all the time.
Thank you all. Have a wonderful day. So that concludes the proceedings today.
Judge, I'm returning Mr. Concero's in-camera stuff, so I can never be accused of wrongfully disclosing that to anybody.